The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good morning, everyone. Our first case is BB, SB, and SB. We will hear from the appellant.
May it please the court. I'm Mike Spivey, representing the appellant mother in this matter. I'd like to reserve 5 minutes of my time for rebuttal. The overarching question for the court in this case is, when we look at the proceedings in the trial court as a whole, can we be confident that they were conducted in a manner that left us confident that the court ultimately reached a reliable result or decision? The appellant says we cannot be, and that the judgment terminating her parental rights should be vacated. Where I would like to begin is what I believe will be a relatively brief but decisive issue, and that is the question of the trial court's arbitrary denial of the motion to continue that was made on the day of the termination hearing when mother was not present. As you know from the record, on August the 10th of 2020, the movement, the Department of Social Services, sent mother a notice in jail telling her that the termination hearing in her case would be held on September 3 at 2 p.m. Later, and the record does not show why, but later that time and date was apparently changed, and a writ was issued to bring her to court on September 4 at 9 a.m. The night before that hearing, mother was released from jail and did not appear on September the 4th. When she did not appear, her attorney moved to continue to have time to see if he could locate her. The trial court summarily denied that motion without allowing even so much as time for a telephone call before immediately proceeding to trial in mother's absence. Now, the court did so, and the reason it gave for doing so was it said that mother had been prepared for court or to be brought to court on September 3rd, and therefore she was aware and knew the case would be tried on September 4th. Nothing in the record supports that finding by the trial court. There's nothing that shows anyone notified mother that the hearing was going to be on September 4th rather than September 3rd. There's nothing in the record that shows she had any reason to believe that the case had not simply been tried on September 3rd and was over and done with. And we'll get into that issue later of how she had historically been left sitting in jail while hearings in her case took place. We expect, although rulings on continuances are discretionary, we expect them to be based in reason and facts, not to be arbitrary decisions. And that is especially true when the ruling on the motion is going to impact a very important or substantial right of one of the parties. So in this case, mother had in effect been misled by the adverse party about when the hearing would take place, and I'm sure that was unintentional. But nonetheless, she was given one date. The hearing took place on an entirely different date, and nobody told her that. And for the court to arbitrarily deny any time, not even time for a phone call, is a gross abuse of the trial court's discretion, and the judgment in this case should be vacated on that issue alone. But that, of course, is not the only problem in this case.
Well, counsel, you recognize before you leave that issue that with a continuous motion being discretionary, as you have acknowledged, how is it that this court would deem that to be, to use your word, arbitrary, considering the fact that there is that level of discretion to which we are to give deference?
It is arbitrary because the court relied on matters that there's nothing in the record to support. In other words, the court said, I know mother had notice of this hearing. I know she knew it was going to be today, because they got her ready to come over from jail. There's nothing in the record that supports that. So the ruling is not grounded in any facts. It's not grounded in any reasoning process. It is simply an arbitrary decision that I'm not going to continue the case.
Mr. Spivey, is it your contention that if a trial court makes a statement of fact on the record, that the trial court is then obligated to explain how he or she knows the accuracy of what's been said?
I don't think the trial court is obligated to explain how they know something. But I do think that whatever facts they rely upon or determine in their reasoning process, it has to appear of record where they came from. The judge doesn't necessarily have to say it, but here you're looking at something that we have no way of knowing from this record where that information came from.
In your view, then, assuming that you're correct, let's assume for purposes of discussion that the trial court had a valid basis for saying what was said. Let's just assume that. What should the trial court have done in order to comply with the rule that you are asking us to adopt in this case, or the decision that you're asking us to make in this case? I don't know, maybe the rule is a bit formal.
I think at a minimum, what the court should have done at that point was at least allowed the attorney time to see if he could locate mother by telephone, find out where she was, and get her into court. That wouldn't have taken but a few minutes. He could have reported back to the court on whether he was successful or not, and then the court could have decided whether to proceed depending on the circumstances at that point. But the court never even gave that much time.
Help me understand how what you suggest should have been done has any bearing upon the sufficiency of the record to support the accuracy of the trial court statement that the mother knew that the court date had been changed from the 3rd to the 4th.
I'm not sure I understand your question.
Well, and I'm not sure I'm understanding your logic, and that's why I'm trying to make sure I understand it. I ask you, in effect, all right, if the court does not have to explain on the record why the court believes the statement of fact that's made to be true, what should the court have done? And what you said was that what the court should have done was allow the trial counsel for the parent to call the mother. If the purpose of the rule is to require there be some evidence of record or some basis in the record for the trial court's factual statement, how does a requirement that the trial court allow counsel without request by the counsel to attempt to reach the mother satisfy the requirement that there be some basis, some explanation of the trial court's basis for making the factual statement that was made? I hope that's not too convoluted.
Well, I think there are two different issues. Whether or not the attorney had time to call somebody is really unrelated to the question of whether the trial court has to put anything on the record. What I'm saying is, in this case, what the trial court did doesn't have any support in the record. We don't know where that information came from. And for the trial court, I don't know how the trial court could have possibly known what went on at the jail the day before. I mean, certainly somebody could have made a phone call the day before. I don't know. But what we do know is that what the trial court did in the situation, the trial court said, I know things. I know she was prepared, and I know that let her know that we're going to have a hearing on this date. And the record doesn't support the trial court statement at all.
Counsel, is there a difference between what you term as being arbitrary on the part of the trial court and what may have been a better practice in terms of the trial judge specifically putting on the record the reason why the trial court felt as though there was at least an assumption that your client was prepared for transport the previous day and made that more clear?
You know, if the trial court had simply said motion denied, I think we would basically be in a somewhat similar position as we don't, it still appears to be an arbitrary ruling. There's no basis at that point. You have what you have before the court at that point in time is you have a record that shows the court that this mother was given a notice that misled her as to the date of the hearing. And then when a motion to continue is made for an effort to have time to locate her, the trial court's immediate ruling is that motion is denied. Now, for the court to do that and deprive a parent of the opportunity to be present at a hearing that may terminate their parental rights without any explanation in the record, I believe would be an abuse of discretion. And here, I think it is more so because all counsel asked for was enough time to see if she could be located, and even that was denied.
So do you have any guidance for us as a court, not just for this particular case, but guidance going forward for trial courts as to what would be a distinction between what would be considered, in your view, to be arbitrary as opposed to what may be simply deemed a better practice in terms of what is placed on the record, especially to guide us in this case today, since you feel as though there's been an abuse of discretion, but yet on the other hand, we're to give a trial court deference on the exercise of discretion?
Well, I think in this particular situation, had the court not relied on something that was totally not a record, but had given some explanation, if the judge had said, well, she hasn't been here for multiple hearings in the past, have been repeated failures, I'm not going to continue this case. Or she's asked for something to explain why the court was making that ruling. Now, you're going to have cases, certainly, and we see continuance cases where both sides have vigorously argued over whether the case should be continued or not. And at the conclusion of the argument, the court just says, well, motion denied. You've got a context. You know what the arguments were. You know why the court acted as it did, or at least you can glean that from the record. All you can glean from the record here is that the mother had been noticed of one date. The date was changed to a different date without notice to her. And then all the court says about that is, well, they got her ready to bring her over, so she should have known we were going to do it today. That's not a reasonable conclusion from, even if she was prepared, why did she have any reason to believe that the case was being tried on the 4th rather than the 3rd when she was told it was going to be tried? Does that address your question?
It does. Thank you.
Yes. If there are no further questions on that issue, I would like to move on to the.
I have one question
Yes.
about that. The termination order in finding of fact number 15 says that the respondent mother was prepared for transport from the jail to the hearing on September 3rd and therefore was aware of the date of the hearing. Respondent mother bonded out of custody on September 3rd, the day before the hearing, for said hearing. What do you make of that finding in terms of whether it has evidentiary support?
Well, first I would say it doesn't have evidentiary support, but I'd also like to ask now, are you referring to the original trial court order or are you referring to the amended order after the notice of appeal?
I'm talking about the amended order.
Okay. No, I don't believe that has support in the record unless you're going to say that the judge's naked statement provides evidentiary support. And I don't believe that it does because in the past, this court has said we don't look to the memory or personal knowledge of the judge. We look to the evidence that's in the record to support findings. So I don't believe there's anything to support that finding. And I certainly do not think the amended order should be considered.
I'm losing your audio again.
I'm sorry. Are you able to hear me now?
I am now, but I didn't hear anything
Okay.
that you said for the last couple sentences before that.
All right. I don't believe that there was anything in the evidence of record to support that finding. And I don't think that order should be considered in any event because I do not believe that the trial court had jurisdiction to enter that order after some 2 weeks, I believe it was, after the notice of appeal had been given.
Okay, thank you.
Turning to the issue of ineffective assistance of counsel, which of course colors this whole situation. I've been through in appellant's brief detailed all of the matters that appellant points to that are acts or omissions by trial counsel, and I won't rehash all of those, although I'll be happy to answer any questions the court may have about those. I am more concerned at this point, particularly as the briefs have developed, about the standard we use to test whether ineffective assistance was prejudicial. Because I think clearly in this case, counsel failed. He repeatedly didn't get mother into court when she was clearly in jail and ready to available. He walked completely out of one hearing and left her unrepresented. So I'm not going to dig too deeply into those issues, but the question then becomes, over the course of this proceeding, is that prejudicial? Now, the lines that seem to be getting drawn on that issue are the language that I see sometimes in opinions, and I certainly see in the briefs in this case, seem to be drifting towards the idea that to prevail on a claim of effective assistance of counsel, you have to be able to prove that you would have won your case, that you would have prevailed, that you would have got a verdict in your favor. And I believe if you go back to the roots of the way we view ineffective assistance claims, that's not the case. We, of course, pulled our test for ineffective assistance from Strickland versus Washington. And in Strickland, the United States Supreme Court expressly rejected an outcome determinative approach to prejudice where you've got to show that you likely would have prevailed. Instead, they focused on whether, when you look at the total context of the proceedings, all of the circumstances, when you look at those, can you say that despite whatever failings there may have been by counsel, that you're confident that nonetheless the case produced a reliable result? Was it a fair trial? So it's not a question of whether you would have won or lost so much is did the process work? Now, when you say, is there a reasonable probability that things may have come out differently? What Strickland did explicitly say is that a reasonable probability is a probability sufficient to undermine confidence in the outcome. That's the test. And yes, that is a somewhat vague test. It necessarily needs to be because of the type of question the court's trying to review. But let's look at that confidence issue in the context of this case. Juvenile cases are somewhat different from criminal cases where we're dealing with ineffective assistance, because while you've certainly got pretrial proceedings in criminal cases, you generally have a definitive trial. Your errors, if there are any, tend to arise out of that trial. Juvenile cases are different because they are intentionally proceedings over an extended period of time that involve multiple hearings. And the whole point of those hearings is to work your way towards a decision about whether you're going to be able to reunify the parent and child, or whether you're going to have to make some other permanent arrangement for the child. And it's critically important that the parent's view, no matter what the circumstances, no matter how well they're performing, it's important that the parent participate in and have some input into all of those proceedings throughout the process. That didn't occur here because counsel repeatedly left mother sitting in jail when she was unquestionably available to the court. Writs were issued. She was brought to court, but not brought in the courtroom. I don't know of any excuse for that. And it's not a question of that was some trial strategy, because you've got a lawyer that stands up at the August 6th hearing just before the termination, a month before the termination hearing, and says to the court, I don't know where she is. I haven't had any contact with her. I have no direction from her. I've got business in another courtroom, and he leaves and tells the court to proceed in his absence. Now, that's not a strategy. So the impact of that, though,
Mr. Spivey, let me ask you something before you get much further in your argument to make sure that I'm following you. It seems to me that the type of thing that you're talking about now goes to the deficient performance component of the test rather than the prejudice test. Is that wrong? It's certainly okay to tell me that it is, but I just
No.
make sure I'm following you, but because you've got to prove to succeed on the claim, you've got to prove both deficient performance and prejudice. And so I'm trying to parse out where we are in your argument.
The fact that he did not get her into court and the fact that he walked out of a hearing goes to deficient performance. It does not go to whether she was prejudiced.
Well, what do you have, assuming that we were to find deficient performance? What showing can you make before us today in support of a finding of prejudice, as you talked about what the test is already? So I'm just wanting to know what about the facts of this case suffice to show prejudice in your view.
The prejudice arises because when this process is going on of determining what's going to happen with the relationship between the mother and her children, the prejudice arises because she is shut out of that process. It becomes a one-sided process. She's not there for hearings to have any say-so or any explanation of what's going on in her life. The court's not being provided with any information about what her circumstances are. You know, a critical issue in this case was mother was in jail.
Again, just to make sure I'm following your argument, is your argument then that in the event that a parent's trial counsel fails to procure the presence of his or her client in court, that by itself is sufficient to establish prejudice because the proceeding has been conducted without adequate input from the parent? Is that your argument?
It is not.
Okay, well, tell me what your argument is then, because that's essentially what I think I'm hearing. And if I'm hearing it wrong, I want to understand what I should be hearing.
What I'm saying is that when you have a process that the parent is supposed to have input in, and you go, in this case, for, I think during all of 2019, I believe mother was I don't believe she was at any hearings in 2019. So you go a whole year of the process going on, and she has no input. The only evidence the court is hearing is the petitioner's evidence, the petitioner's side of the case. Nobody is telling the court what services are available to mother. When is she in jail? Why is she in jail? How long is she in jail? What services are available to her? What's going on in her life outside of that? Is she employable? If she's not, what's the problem? All of this information the court needs about the parent, the court's not getting because the parent is not there. And this is not a case of the parent not being there on one occasion. It's not a case of the attorney standing up and saying, Judge, my client has knowingly elected not to participate. We're waiving her appearance. This is a case where throughout the whole case, she is shut out. Even though she's available, she's helpless. She has to rely on her attorney to get her in court, and he doesn't. So her side of the case never gets heard. And that's where the prejudice lies.
Counsel, under your theory, does the respondent have any obligation at all to take the initiative to seek to communicate with her attorney or otherwise participate in the process?
Yes, absolutely. A respondent has an obligation to remain in contact with their attorney. But we have to keep in mind that when a respondent is incarcerated, their ability to do that is going to be hampered. And we need to look at to what extent has that been hampered and what extent does that impact her ability to contact her attorney. We don't have a record in this case that she was not failing to contact her attorney. What the record shows is her attorney was failing to contact her. And that's a very different situation.
Well, is that precisely what the record says, or is the record silent? Do we need to put the attorney on the witness stand and say, Mr. Attorney, go back through all the notes in your file and reveal to the court every attempt you made to communicate with your client?
I think that would depend a great deal on the circumstances of the individual case. And I certainly think in many cases, you would have to remand the case to the trial court and find out what was going on and why the attorney didn't do it. But what you have here that you don't have in a lot of cases is you have an attorney that, and I come back to the August 6th hearing, that after he has repeatedly not brought mother into court when she was there on a writ, he stands up and tells the court that he doesn't know where she is and has no direction, no contact from her. But everybody else in that hearing on August 6th knew she was in jail. The court knew she was in jail. The court made a finding about that. The only person in the courtroom that didn't know where she was a lawyer. So I think in that context, you can look at the facts and circumstances of this case over time, and you know that this attorney was not effectively communicating with an incarcerated client. And I see I'm running very low on the time I had reserved for rebuttal. So if there are not further questions at this point, I'll reserve the remainder of my time.
Thank you, counsel. We'll hear from the FLE.
Good morning, Chief Justice Newby and the Associate Justices. May it please the court. My name is Tom Griffin. I'm with Parker, Poe, Adams, and Bernstein. I have the honor today of appearing on behalf of the juveniles in the North Carolina GAL Appellate Program. And I have the honor of appearing today with Ms. Amanda Perez, who is here representing the Burke County Department of Social Services. Ms. Perez and I will split our time, and as best as we can, I will begin by addressing the topics raised by Mr. Spivey on ineffective assistance and notice and the continuance, and Ms. Spivey will address the order and the grounds, but of course, we're both available to answer the court's questions. So I'm going to jump right in. I'm going to rejigger my outline in response to some of the things that appellant has argued today. And the first thing I think that's important to do, well, just at the outset, I believe we're kind of jumbling up the Strickland test. The totality of the circumstances test goes to the evaluation of an attorney's conduct. The Supreme Court very clearly said, and I'm quoting, the defendant must show that there's a reasonable probability that, but for counsel's unprofessional errors, the result of the proceeding would have been different. So there is a how would things turn out differently component that's very clear. Now let's jump to this narrative. The narrative that Mr. Wilcox, who is, I'll refer to him as that, the trial counsel, left appellant sitting in jail and not participating in the hearings, because that narrative runs through their argument, as you've just heard, and affects the continuance decision. So there's two aspects of that. One is the writ process, and one is what does the record show? And so let's think about what happens with the writs and what could happen if appellant doesn't show up. The court issues a writ to the sheriff and says, bring appellant to jail. So if appellant doesn't show up, there's a few possibilities. One is the writ was issued, the sheriff got it, ignored his or her responsibilities. Unlikely. The second is the sheriff went to the appellant's cell, said you're going to court, she refuses to go, and the sheriff says, okay, you don't have to go. Again, unlikely. The third is that the writ is canceled. There are a few instances of writs being canceled in this record. And the fourth is, and I would contend this is the most likely, that the appellant wasn't actually in jail. And that's what happened to the TPR hearing. But now here's what the record doesn't show. That Mr. Wilcox has any role in that at all. There's no evidence that he said to anybody, please don't execute this writ. Please don't bring my client to jail. There's no evidence that the appellant was brought to court and that Mr. Wilcox said to anybody, please have her sit out in the hallway. I don't want her in court. There's nothing there. And that doesn't make sense. And so I don't think the record supports at all that Mr. Wilcox had an affirmative role in leaving appellant anywhere, either in jail or in the hallway. Now, what the record does show, if you parse it through, and I tried to think of a pithy way to describe all the hearings, it's not possible. I counted 8 or 9 where writs were issued to have the appellant show up. And here's an interesting thing. There were 2 hearings that we've not discussed yet where appellant was brought to court on a writ, both for a TPR proceeding that was then continued. I know one of them was the February 6, 2020, the order is at record 228. The writ is at 226, it looks like. The order itself for the TPR continuance says that the appellant was there, right? Now it's continued, but she was brought to court. Now there's another TPR hearing that was going to be held at the same time with the permanency planning hearing on June 11, 2020. The TPR record order is at 248. The permanency planning is at 251. There were writs issued. The permanency planning hearing says that the appellant was present. The TPR order is silent. So we don't know if she was in the court or not. We can assume that she probably was because she was brought to court, but maybe they said the TPR hearing's being continued, so we're going to send you back. But she was brought to court for hearings. She didn't have an expectation that she would be left in court for important things going on. And so when you look at this, there is that one hearing on the 6th of August, 2020, where the court excused Mr. Wilcox and she wasn't in court. We know she was in jail. We don't know why she wasn't there. We do know the record doesn't say anything about Mr. Wilcox saying she shouldn't be there. The only thing I can figure out is there's an inference of confusion because at least one of the writs was canceled. And the writs for that hearing are at 300, I think, thereabouts in the record. And one of them says canceled for the father. Maybe the sheriff was confused. But what we don't have is any record evidence that Mr. Wilcox did anything to leave appellant anywhere on his volition. So the record doesn't support that. So now how does that roll into the bucket? I had these things in buckets in my head of issues, into the topic about notice and what went on at the TPR hearing. So we now know that the narrative that Mr. Wilcox had something to do with the appellant's absence and that she was used to having hearings going on without her is not supported by the record. And admittedly, the record is confusing. Right? There's a couple places when she didn't show up, I couldn't figure out if she was in jail or not. But if you look at the likelihood, it's possible she was bonded out like the TPR hearing. But nevertheless, there's not that underlying narrative. So what happened? The question becomes, is it appropriate for the trial judge to infer that the appellant knew that the hearing was the next day? Yes. The notice for the hearing said, you need to be in court on September 3rd at 2 o'clock. But the writ says, Mr. Sheriff, bring her to court at 9 o'clock in the morning on the 4th, right? First session, first thing in the morning on the 4th. So what's reasonable to assume? It's reasonable to assume that the sheriff informed the mother the day before. Is this a reasonable inference? I would submit that it is, that you need to be ready for court the following morning. In other words, she's not going to show up at 7 o'clock in the morning and say, Miss Appellant, get yourself ready. We're off to court. He's going to go tell her, the sheriff or the bailiff, is going to go say, you need to be ready tomorrow morning. Prepare yourself for transport. And so the question then becomes, is it an appropriate inference for the judge to say, I'll deny the motion. I will note for the record that she was prepared for transport yesterday at some point. So she knew of today's court date. She did bond out, ... despite the fact that she was aware yesterday and prepared to come to court yesterday. So the language is a little bit confusing when you put the yesterdays in different places. But did the judge have information in the record from which he could infer that the mother knew that her hearing was on the 4th at 9 o'clock? Absolutely. It's reasonable to confirm that she was told.
Where would we draw the line? It's Morgan speaking. I see your eyes, counsel, looking across the screen. Where do we draw the line between what you term as a reasonable inference that is not affirmatively supported in the record with any facts, as compared to what opposing counsel is saying is that is arbitrary because there is nothing in the record to support what you term as an inference?
Well, Your Honor, that's a good question. If for abuse of discretion, the appellant has to demonstrate that it's manifestly unsupported by reason. Manifestly unsupported by reason. Is there anything in the record that would support the reasonable inference that the appellant knew? Now, what's not in the record is that she didn't know. I mean, the briefing is that the statements that she didn't know. We don't know that she didn't know. And what the counsel says what the counsel said at the hearing is a little bit confusing too, but he just says, she's out. I haven't contacted her. So we don't know that she didn't know, but we do have information that says that the judge's decision is supported by reason. I don't think there's not a rule this court, not that I'm aware of, that we've adopted. You have to have findings of fact to support a denial of a continuance motion. Now,
Is that where deference comes in terms of the exercise by this court to a lower tribunal to give deference to discretion being used? Or should there be some requirement? Or should it just be a better practice of a trial judge to say more about the reason for such an inference?
Well, I believe that it is deference, Your Honor. I mean, the trial court's running his proceedings. He's read the record. He obviously concluded that she had been ready for transport the day before. I mean, he wasn't making that up. So I'm assuming that he understood what the record told him. So we do need to defer. I would hesitate to set a test that in every proceeding we have to ask and answer the following questions, because I think every case is different. That's why it's abuse of discretion. So I would look to see if it is supported by reason or manifestly unsupported by reason. And so I think in this case, the decision was supported. Now, critically also, appellant has not demonstrated any prejudice from her absence. Right now, prejudice is actual prejudice, as for the IAC claims, ineffective assistance of counsel for Strickland has not been demonstrated. And she hasn't, the appellant has not talked about how she could have handled the hearing differently. The hearing could have been handled differently if she was there.
Okay,
It's not.
Can I ask you a question about Justice Searles here?
Yes, I'm looking like this. So.
Yeah. Hard to find me, but I'm here.
Yes, ma'am.
A question about the problem of lack of evidence in the record and how that relates to ineffective assistance of counsel. And it seems to me that the ineffective assistance of counsel also relates to the denial of the motion to continue. Because if an effective counsel had communicated with his client, he could have either explained to the court where she was, why she wasn't there, why she needed a continuance. But if you have a counsel who not just on this single occasion, we're not talking, at least as I understand the petitioner's argument, she's not talking about a single incident, but throughout the course of this case, her not receiving effective assistance of counsel. So her counsel is not advising her of her rights. She's not able to present what information she might have related to the case. How then, if a counsel is ineffective in representing you, how then can you have a record that demonstrates how you would be prejudiced? I mean, doesn't this sort of cry out for a remand to fill in the facts that you've already said just don't exist on the record?
Well, that's a good question, Justice Earls, and let me answer it this way, which is that the appellant has the burden of demonstrating that her counsel was ineffective, didn't meet a standard of reasonableness of using the totality of the circumstances throughout this case. So far, she's just said it. So here's what we don't have in the record. And I think the implication for Mr. Wilcox, who has represented the plaintiff, the appellant since his appointment at the very outset of this case, I think the implication is unfair, because what this record does not have is any evidence that he did or didn't do anything that the appellant said he did or didn't do. There's at every single hearing, there's no transcript that says he was good, bad, or in between. There's no transcript that he did make an argument or didn't make an argument. There are no emails, there's no affidavits, there's no correspondence, there's nothing. And so the appellant in her briefing suggests that it was our responsibility, the GAL program or DSS, to put that information in the record if we wanted to prove competence. That's reverse. The appellant needs to prove that Mr. Wilcox didn't perform competently all the way throughout all these hearings. So we don't know. And so then you look at the record, Your Honors, you suggested, and say, what is in the record that would support an inference? I don't think that even works, but nevertheless, let's say there's an inference that Mr. Wilcox could have done a better job at any particular hearing. And her main two complaints, and I may be leaving one out, are visitation and making sure the findings and the orders are appropriate. Right. So if you look at the DSS reports and you look at the findings, this case does not have nuance to it in terms of compliance with the case plan. It doesn't say the parent had to attend 7 parent pending classes and she attended 3, or she had to get a substance abuse assessment, which she got, and needed services and she's sporadically done. All the way throughout the entire case, the theme is consistent. She didn't comply with the case plan. She didn't get this assessment. She didn't do a parenting capacity test. She didn't refrain from criminal activity all the way through the case. So there's nothing in the record that demonstrates that Mr. Wilcox should have done a better job. So the record is silent on anything from which we can determine that he didn't act reasonably under the circumstances. And the record has information which suggests that there's really not much he could have done. So you can't infer inappropriate conduct or ineffective assistance. And then you look at the prejudice test for these earlier hearings and how they roll up. There's no information that's been provided by appellant that any particular hearing, there's a reasonable probability that it would have turned out differently. Mr. Wilcox had done something. We don't know what he could have done because it's not in the record, but there's no indication that any hearing would have turned out differently. And it's a little bit like hearsay with.
Let me make sure I understand what you're saying. So you're saying that on appeal, the burden is on the petitioner to submit affidavits or other evidence on appeal? Because alternatively, are you saying that her trial counsel had to create his own record that he was being ineffective?
No, Your Honor. What I'm saying is on appeal, there has to appear in the record some evidence that the counsel didn't act reasonably under the circumstances. There has to be something. We can't just say, and let's say like at an early review hearing where Mr. Wilcox was present, it's on the 7th of March, 2019. At least my records say that the appellant wasn't there. Mr. Wilcox was there. So the allegation is that he didn't do his job at that hearing. I don't know what he did or didn't do. I don't know if he did a good job or a bad job or somewhere in between, as I said. There's nothing in the record. So it is the appellant's obligation to demonstrate to this court on appeal that her counsel didn't perform reasonably under all the circumstances. So let's look at the record. Let's look at what's available. I don't think counsel has to defend himself all the way through by having affidavits say, by the way, at this hearing, I did a good job. I think in retrospect, that this court and Strickland affords trial counsel a wide range of reasonable presumption of his or her conduct. And it's up to the appellant to show that didn't happen. And it's also up to the appellant to show that the results of the hearing would have been different. Now, so she also has to show that had these earlier hearings would have been different, there's a reasonable probability that the TPR hearing would have been different. And she hasn't shown that at all. And so all I'm saying is we don't know. And it wasn't DSS or the GAL's burden to demonstrate that we did know. And let me turn briefly to the TPR hearing where Mr. Wilcox sat silent, and I'm going to turn the reins over to Ms. Perez. And that is, we have to apply the Wilcox test and say, what the decisions that Mr. Wilcox made at TPR hearing, were they reasonable under the circumstances? Now, the appellant has directed this court to the professional guidelines for attorneys who represent indigent parents in the juvenile proceedings. And I want to read a section from that guidelines very briefly. It says, counsel should, this is 4.4a on page 21. Counsel should develop in consultation with the client an overall defense strategy. In deciding on defense strategy, counsel should consider whether the client's interests are best served by not presenting evidence on behalf of the parent and instead relying on evidence and inferences or lack thereof from DSS's case. So what that's telling us is that silence is an appropriate strategy when it's appropriate. And Strickland tells us you got to give somebody wide berth. And so you look at the record and you realize that Mr. Wilcox, there was nothing for him to work with. There's no nuance to argue. And so,
but there's also no evidence in the record that he ever had that conversation with his client, and together they decided that was the best course of action on her behalf.
I think it would be difficult. You're right, Justice Earls. At least I don't know of any. And I think it would be difficult, though, to require counsel to document everything and get into an appellate record every conversation they've ever had. I think we need to presume that the counsel is doing a good job, absent information otherwise. It's up to the appellant to demonstrate ineffective assistance. It's not up to the counsel to prove that he was effective, or up to us on appeal to prove that Mr. Wilcox was effective. It's a question of burden. And when you go to that burden and you realize that she has not shown how she was prejudiced, what testimony could have been brought forward, what objections might have been made, where in the record things might be different, what she would have testified to, we would submit that she did not meet that burden. So yes, the record is deficient, as you pointed out, Justice Earls, on giving us a complete roadmap. But it's the obligation of the appellant to fill in the rest stops and the way stations along that roadmap and give us that story. And she didn't do it. And for that reason, we would submit that the ineffective assistance of counsel claim is not well-founded, and that the trial court's decision on the continuance was well-founded, and both those should stand. And absent any further questions, I think I've left Ms. Perez about 11 minutes.
Thank you, Mr. Griffin. And good morning, Your Honors. May it please the court. I'm Amanda Perez. I am representing Burke County Department of Social Services. And I'd like to start by addressing the amended order that was entered after the original order. The original order that was entered contained a clerical error. As mentioned in my brief, I believe that one of the children's names was missing their last name, and therefore the trial court or the clerk asked DSS to enter an amended order correcting that mistake. In the process of that, some findings of fact were also added to the amended order.
Is Ms. Perez, I mean, is it your contention that in the event that any clerical error is corrected, the trial court then has the authority to make any and all additional findings that the trial court elects to make?
No, and I don't believe that, I'm not confident that the amended order was entered correctly, but I don't believe that the court has to address that issue because I believe that the original order that was entered is sufficient on the findings of fact to support grounds for termination for the respondent mother.
But in just to make sure I'm following the way that you're asking us to analyze this case, is what you just said in essence a suggestion that we look to the original order and not worry about what the amended order says for purposes of determining whether there are grounds for termination?
Yes, correct.
And that would suggest then that we ought to just ignore the additional substantive findings that were added to the amended order in conjunction with the correction of the name error that you mentioned a minute ago.
I believe that that is something that the court could do and that there would still be findings of fact sufficient to support grounds for termination.
All right, well, let me make sure. I thought I understood you, maybe I didn't. Is it your contention that the trial court has the right, once a notice of appeal has been filed, to enter an amended order that corrects a single clerical error and then adds a whole bunch of substantive findings of fact?
Well, under Rule 60A, the court does have the ability to change clerical errors. And I believe that respondent mother referenced a case, she referenced CNCB, stating that a change in order is considered substantive when and outside the boundaries of Rule 68 when it alters the effect of the original order. And that in that case, the court found that the amended order was not proper because there was only one ground found, and the necessary fact that the court added to the amended order was not in the original order. And in this case, the changes that were made would not affect the outcome of the case. I believe that the grounds were sufficient.
They did have the effect of substantially bolstering the strength of the findings used to support particular grounds for termination, right?
Correct, yes.
Is your contention that that's not substantive?
It is substantive to the grounds, but I don't think it alters the effect of the order, of the original order as stated in C and CB, because you could still find termination.
Is it your contention then that as long as that it is nothing more than the correction of a clerical error for a trial court to add multiple additional findings of fact, as long as there is no change in the identity of the grounds for termination found in the order?
I think you could get that from the case that I cited, because it was talking about in CNCB, it was talking about a case where they only found one ground, and that in that case they added a necessary fact. I believe it was dependency. They needed to find that there wasn't an alternative appropriate childcare arrangement that was not in the original order. And so by adding that later on, it essentially changed the outcome of the order. And in this case, the outcome would not be changed by the amended order because there were sufficient findings of fact in the underlying order.
Hypothetically, and I don't want to beat this horse too much further, but hypothetically, if we had an order that found a ground for termination the ground is set out in the amended order was not sufficient, but the findings added in the amended orders were sufficient to support that finding of that ground for termination. I take it you would consider that set of circumstances to be a substantive change.
Yes, I think that would fall in line with C and CB, where if it affects the outcome, if the amended order, the findings were necessary to find that ground, I do think that would be a substantive change.
And you'd have to make that determination on a ground for termination by ground for termination basis.
Yes, I think you'd have to look at the context of the situation, whether the underlying order was sufficient to find the grounds like it was in this case, or alternatively in C and CB, it was not.
All right, thank you.
You're welcome. So while I do think that
Before you leave that, sorry,
Sure.
before you leave that altogether, are we also to ignore the amended order to the extent it addresses the motion to continue and the service of the writ?
I think that you would have to look at the amended order and decide whether the change was substantive. I believe, as Mr. Griffin argued, that there is an inference from the record and from the transcript, and giving deference to the trial court, I believe the motion to continue was correct and it should not be overturned. I don't think that you necessarily have to address that. So I think that you could ignore that in the amended order.
Am I correct that there's only a transcript of the September 4th hearing?
As opposed to what happened on September 3rd?
Or as opposed to what happened after the original order was entered?
My understanding is that the only hearing occurred on September 4th, 2020, and there weren't any further hearings after that date.
So there was no hearing before the amended order was entered in
Correct.
November?
Correct.
Okay, thanks.
You're welcome. Thank you. If there are no further questions on the amended order issue, I will move on to whether the findings of fact are sufficient. And given what I argued earlier, I'm only going to be talking about findings of fact that were entered in the original order, because I believe that those are sufficient to find what's needed to support grounds. Respondent mother starts by arguing that the trial court did not make appropriate findings of fact in regards to neglect and the likelihood of future neglect. The trial court has to make a finding of fact that the repetition of neglect is probable, and that was included in the original order. In addition, respondent mother argues about incarceration and whether that is a sword or a shield. It can't be used as a sword or a shield, and alone it's not enough to show neglect. That is true, but in this case, the children, part of the reason that they came into care is because the respondent mother was incarcerated at the time that the non-secure was entered. They were staying with the father because the mother was unavailable and they were found to be living in a car. They had various health issues. And so the respondent mother was unavailable to provide care for them because she was incarcerated. She knew that that was the reason that she was unavailable at the beginning, and she continued to reoffend throughout the case, serving short stints of time in jail and continuously reoffending and being rearrested. Now, in regards to whether or not she completed her case plan, the evidence is clear from both the transcript, the findings of fact, and all of the prior hearings and evidence and record that she did not complete any aspect of her case plan. And respondent mother makes the argument that KDC, it addresses when a parent is incarcerated, that the court has to find what they were able to accomplish while they were in jail, what services were available to them while they were incarcerated. That case is completely different from this case, because in KDC, the parent was incarcerated from the beginning of the case all the way through serving the same sentence. That parent had to show, or the DSS in that case had to show that that parent had access to services. In this situation, she continued to reoffend. Yes, go ahead.
In your last minute, I was particularly interested in any comment you could make on the Judge Barkley dispositional order that was stipulated to by, that did show neglect, that was brought into the record. I know you only have a few seconds left, but if you could address that, please.
And you're talking about an adjudication disposition, they stipulated to the disposition.
Yes, as a reminder, and you only have 44 seconds left, so it may not be able to be answered, but my reading of the record shows that there was a stipulation to the fact that there had been a finding of negligent or neglect, excuse me, of neglect, and it came from an order from Judge Barkley, a dispositional order, and that the respondent did stipulate to that. Is it your position that perhaps this may also show that there is neglect in this case?
Correct. Yes, the parents did stipulate, or at least the respondent mother stipulated at adjudication disposition that neglect was found. So that was, they were adjudicated to be neglected at that time, and she did stipulate to those facts.
My apologies for taking your last few seconds.
That's fine.
Thank you, counsel. Rebuttal.
Let me speak quickly to the remark that was just made about mother reoffending and being reincarcerated throughout the case. That's not, I believe, an accurate portrayal of the record. What we can tell from the record, which everybody agrees lacks a lot of clarity, is that the last offense date for anything mother was alleged to have done was in August of 2019, over a year before the termination proceeding. The reason the record here lacks clarity is because trial counsel failed in his duty to develop a record that we could look to. We have the appellee guardian ad litem saying to us, well, if you look at all the evidence in this case, you can't possibly prove ineffective assistance of counsel because you've got no evidence to support it, which falls back to the argument of, yes, if you only hear one side of the case throughout because counsel did not do his job, then the surest way to avoid ineffective assistance of counsel is to do absolutely nothing from the day you begin representing the client, because then there will never be any evidence to be produced to show what would have happened or what evidence you would have had. And again, that comes back to that's not the standard. The standard is you look at the counsel's performance, and if it was deficient, and we say that it was in this case, then we look at, considering the whole context of the case, are we satisfied, given those failures to perform, that this was a fair proceeding that produced a reliable result? And if you look at the record as a whole in this case, you cannot say you have confidence in a proceeding where counsel did no more than he did in this case. And I take issue with what appellee guardian says about you can't show on this record that counsel did, that it's his fault she wasn't in court, that he didn't act to keep her out of court. That's not the question. His duty was to get her into court. His duty was to advocate for her. His duty was to pursue visitation. His duty was to develop a record of favorable things if there were any. If there were no favorable things, his duty at hearing after hearing was to offer explanations or show mother's side of things. His duty was not to leave her after 2 years with a record that shows virtually nothing about her circumstances. That's where the ineffective assistance arises, is in his failure to do all those things that would give us a record of evidence where you could make a fair judgment about whether her parental rights should have been terminated. The trial court wasn't in the position to do that because the trial court didn't have that information. You know, they talk about, well, she was out of jail at some time. She was out, okay? Then what the trial court needs to know is, was she out for a week? Was she out for a month? Was she out for 3 months? If so, during those periods of time, what did she do? Well, that's trial counsel's duty to get that information before the court. For good or ill, get it out there so the judge what all circumstances were. Here, you have none of that.
Didn't counsel bring up the fact that she had completed a program properly and fully?
I don't believe that if you're talking about at the termination hearing, he asked a question about had she come over for some or inquired about a particular program. I don't think there was anything offered to say she had ever completed that program. And that's the only instance I know in the entire record where anything even approaching any representation occurred.
I don't
So
want to take up your time. Go ahead.
the end result of all this is, if you step back and look at the entire proceeding from start to finish, where we're trying, and admittedly, neglect occurred. That was adjudicated at the beginning of the case. It was stipulated to. But the question is, after that, when we're working the process of determining what's going to happen to this relationship between parent and child, are we confident on this record that this mother received effective representation, a fair hearing, and the trial court was able to make a reliable decision? And I say we cannot, and the judgment should be vacated. Thank you.
Thank you, counsel. Madam Clerk.
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina will be in recess for 15 minutes. God save the state and this honorable court.